has struck down key sections of the law, raising fundamental questions about digital rights, governance, and the future of the regulation in Uganda. So, as justice has been served, is the country also looking to a critical tool in fighting cybercrime being adjusted and in favor to protect mostly rather than to punish? Well, the guests joining me for this conversation will help me find the justice between the lines. To my immediate left, I do have Margaret Natavi, female youth councillor for Mukono Municipality, and next to her, we're being joined by Douglas Derek Onen, who's a human rights officer with the Center for Constitutional Governance, and both are here to allude to us on this matter. Both of you, thank you so much for joining us. Now, Onen, because it's Women's Month, the onus goes to
Please do.
the lady on the table to give us your salutations and greetings.
Good morning, our dear viewers. Thank you for watching NTV, and thank you for following us. We're going to dive into this conversation. And we see how this entire bill came in place, the act, and what really had to go out and what we really had to remain with for the better future of our country.
Okay, all right. And then?
Thank you. For me personally, I'm very delighted to be here to have this discussion. I think what is fundamental in this discussion today, it is not just a matter of the Constitutional Court striking down a bad law, but it's significant because it shows that as a Ugandan state, this is a long, it shows a long political tradition of the state trying to curtail freedom of speech. So I'm looking forward to having a very interesting and robust discussion. All right.
The Daily Monitor is calling it inside the rise and fall of the Computer Misuse Act. Let's start with the rise. Back in 2011, they were responding to the rising cybercrime and digital expansion, but something clearly did shift in 2022's enactment. Now, in 2022, some of the key provisions that were put or added there, your criminalization of unauthorized access to data, ban sharing information about children without consent. Then you do have Section 26 that looked into penalizing content that ridicules, demeans, and degrades others. You also do have prohibiting sending malicious information in Section 28, and then Section 29 had restrictions on social media misuse, including false or disguised in the identities, and then also increasing penalties, fines of up to 750 currency points or imprisonment of up to 10 years for serious offenses. Now, some of our brothers and sisters have already faced this particular one. But as we look to it, the rise of this law, to begin with, Margaret, for you as a youth and digital participating person on the space, we want to find out from you, did the amendment actually reflect the realities of young people online?
First of all, this amendment didn't really come in the sense of stopping computer misuse per se. It came basically to silence. And if young people want to criticize, because we have to criticize, we have to ask for accountability from our leaders. If we have to speak up out anything to do with the politics of our country, we have to be free. So this amendment really affected young people, that me inclusive and so many others. Sometimes you wanted to speak about something and you really see something is wrong, but then you're pulled back by the fact that there is a law that you might face even after speaking something that is real. So our voice has been curtailed, really. But given that now the amendment has been scrapped off, I think we can freely share, we can freely post, we can freely speak about anything without any fears.
All right, Douglas, from a legal perspective, I want to understand from you, were the seeds of the problem already existing in the original law in 2011?
Thank you. I think for us to first of all have this discussion, as earlier noted in my introduction, I made mention and said that what the Constitutional Court did wasn't just striking down bad sections of the law, but it is significant because it exposes a deeper problem in the Ugandan state. And what is that deeper problem? The deeper problem in the Ugandan state is how the Ugandan state imagines authority, how it imagines dissent, how it imagines language, and how it imagines public order. And that is going to be the center of my discussion today, because it's deeper than just us here mooting the law. But let me first address the question that you have asked me. In 2010, on 1st of November 2010, the president assented to the Computer Misuse Act. And of course, it came into force in 14th of February 2011. And when this law came into place, for all those years, the law was perfect, because the essence of the Computer Misuse Act was to go ahead to provide safety and regulations for electronic transactions and information systems. The way it was perfect, right until 2022 in the month of September, whereby Honorable Muhammad Nsereko, then the MP of Kampala, went ahead and tabled a bill calling for an amendment, of which the amendment passed, and on 14th of October 2022, the president assented to it quite fast, considering we have a number of bills and a number of laws that are quite significant to Ugandans that have been on the floor of parliament for years. For example, laws relating to transitional justice, among others. But let's focus to the essence at the moment. Your question asks whether there has been a problem with the law. The law was okay the way it is. I know NTV hosted the president of Uganda Law Society, Mr. Semakadi, on one of the shows here where he discussed that the law was okay. The issue was with his argument was the issue is with the judicial system. Now, what we see in that Honorable Nsereko bill, it introduces draconian amendments to the law, and that is where the problem comes. And as I mentioned, that you see, the problem that we have with this amendment, that it is going ahead to, first of all, curtail speech in a situation whereby you threaten the speech of people. That means you also threaten the state of democracy in a country. So the law that was passed in 2011 was okay the way it is, right until the amendment came into place. So further on in my discussion, I will show you how deeply the problem is, because my discussion isn't just about mooting the law. My discussion in this particular show is to show you that, you see, the Ugandan state the way it is today, the problem is how the country imagines authority, how the country imagines dissent, how the country imagines language, and how the country imagines public order. Mm-hmm. And that comes down to curtailing the freedom of speech, which of course dates back from as early as 2002 to 2001 in the case of Charles Onyango-Obbo. But thank you.
Okay, all right. The law quickly becoming associated with arrests after the amendment. Activists, journalists, TikTokers, and social media users on an ordinary day, and often under the charges of offensive communication. Maybe to just help us understand, by law, what is regarded as offensive communication?
You see, the Constitutional Court in its ruling went ahead and said that the language that is used is vague. And offensive, according to the law, is quite ambiguous. And offensive could primarily mean someone who goes ahead and speaks bad in the person of the president or certain particular individuals. And the people who have actually been charged with this particular law are individuals who have either spoken bad on the person of the president or certain particular figures in our society. So using that metric, that is the definition of the offensive that we think this law goes ahead and opines with. And that is why the Constitutional Court comes ahead and says, you know what, the language used is vague. Now, to that extent, that I've answered your question right on, I think we now need to look at the deeper issue for discussion, which is the issue of legitimacy. When we go ahead and pass laws that go ahead and hinge and infringe the freedom of speech of individuals, you see, the issue at the moment isn't just a matter of digital repression or going ahead or digital regulation. Mm-hmm. The issue is on the question of legitimacy. Professor Ogea Otunu, in his book, Crisis of Legitimacy, talks about how states that oftentimes find it very hard to go ahead and assert legitimacy. Legitimacy can both be moral and political. In a scenario whereby we do not have legitimacy from the citizens, so how do you then go ahead and ensure that you get that legitimacy? What do? You go ahead and control what they say. You control what they speak, what they post. So in a scenario whereby you go ahead and for you to go ahead and to provide for yourself legitimacy, you have to curtail what they speak. And that is where the problem is. And that is why the ruling by the court, it's just a reminder that you see, Ugandans have a right to speak, and they ought to speak. They must speak. Ugandans have a right to criticize. Ugandans have a right to ridicule. Ugandans have a right to dissent with their leaders. In a scenario whereby you go ahead and introduce a law that curtails the right to ridicule, the right to criticize, the right to call you out, then that is not a democracy. You are trying ahead to repair legitimacy question that you do not have. So I, of course, applaud the Constitutional Court with a law that, with the ruling that they went ahead and passed, which is a landmark ruling, and it would help, of course, answer questions that are very important with the freedom of expression and speech.
Okay. We also have to be realistic of the fact that some controls are necessary, or some measures are necessary to ensure that in whatever people want to express themselves about, they do it in a manner that is respectful and that is, you know, cordial to everyone that is going to be receiving this form of expression or liberty of speech or at the end of the day. This is why I want to bring you in, Natavi. Are controls not necessary?
Controls are very necessary, but we must also understand in what spirit are we bringing these controls. If you go back to how this amendment was tabled, in what spirit did the Honourable that tabled the amendments or the bill come with? He was facing, particularly, personally, some criticisms from the public, and before we knew it, he was tabling the... Yes, the controls are necessary, and like he said, the earlier act that we had was okay. It was okay. It could control everything that we needed to control. But when you look at these amendments, they didn't really want to control the kind of control you need, but they were more like personal. And that's why when you see the penalties that came along with these amendments, they were targeting people in public office, basically. If you are maybe convicted, you're going to start from public office for 10 years, you get. So they were targeting a specific group of people, not to control the public per se, like you said. If we wanted to control the necessity, then the actual bill we had was okay without any amendments.
How do you assess the law's performance in objectivity between 2022 and 2026?
The performance, I think it has affected most of the people that were targeted. We've seen so many young people that have tried to speak, to express themselves, being targeted. Some of them have been charged, others have been convicted, others are still in remand. And it looks more illegal, and I pray that by the end of that day, because we have seen particular laws like the court-martial, people that are still suffering on it, even when it was scrapped off. So even this one, yes, they have been scrapped off. We are not very sure that the people that are charged by this law are going to be freed at the end of that day, but we pray they are.
Okay.
So,
on that note, Onen, what are the legalities around people who had been charged by the provisions that were added to the original law in 2022, between 2022 and today? But also what happens to those whose cases are still within the corridors of judiciary?
Unfortunately for people who have been charged and sentenced and possibly served their sentence, there is some redress, and my call out to those victims is to seek out for legal help. But for individuals at the moment, for the likes of Male Mabilizi, Ibrahim, aka Pressure 24/7, right now it's a call to the new DPP. He needs to show that he's actually the man for the job, because the Constitutional Court has gone ahead and announced certain provisions of this particular act and law unconstitutional. So it's a call for DPP to go ahead and release these individuals, arraign them before court, and of course release them. That is the only legal redress that is available. But in addition to the argument that my sister was making in regards to the interest of the elites, particularly, I would term that law, or the amendment that was tabled by Honorable Muhammad Nsereko as an elitist interest that he was trying to table. Individuals who, of course, these are post-colonial tendencies that we often see with people who have power, that the only way for you to, of course, when someone is attacking you, since you know you have the authority, you have the power, and you on the floor of parliament, you go ahead and pass a particular law that serves your individual interest. And I think that is fundamentally wrong. Because for us to move away from scenarios whereby you pass a particular law that criminalizes people's freedom of speech and expression because you're trying to protect your certain interest, that creates a very huge problem in the system. But I think something that also interesting that I want to talk about is on the issue of violence. Violence in regards to how we use the law. You see, oftentimes we think violence is about the barrel of the gun, but violence can as well be institutional, and institutional in a way that you have an equal ways on laws that we pass. For example, this amendment that goes ahead and criminalizes speech, that is institutional violence in its own self. How many people have been charged under this act on grounds that, of course, you have gone ahead and provided criticism, you have ridiculed, and you're taken in and you serve sentence of not more than 10 years or not more than 7 years. That is, of course, institutional violence. So my call out, first of all, is to Ugandans to understand that they need to be more keen on issues that are discussed on the floor of parliament. They need to be very, very keen and also call out their members of parliament. Of course, the grounds that the Constitutional Court said that that they used was there was minimal quorum. What in a scenario whereby they bring back the same law on the floor of parliament and there is quorum.
And they mobilize.
Yes. So what must Ugandans do? And that is why Ugandans must be very, very keen on what the members of parliament do. But also civil society organizations are doing fundamentally well. You know, a number of civil society organizations that have been part of the case, inclusive the institution that I serve under, Center for Constitutional Governance. They have played a very critical role in trying to help fight for the rights of Ugandans. But we can only fight as much. Ugandans ought to also speak for themselves.
Back to the constitutional rights, which ones were more at risk under the amended law?
Under the amended law, the most at risk was the freedom of speech and expression. Article 29. That was the most fundamental issue that was very critical and was at the heart of the amendments. The amendment of 2022 introduced a couple of sections, particularly under Section 23. If you look at the amendment, there were approximately 6-7 amendments that were introduced introducing hate speech, introducing among other amendments that were quite fundamental to the heart of the act.
Okay, all right. We have seen security and freedom also being one of the embedded reasons as to why this amendment did take place at the heart of this debate. So it's a familiarity that we've seen, especially given the fact that we've just gone through an elective cycle. You saw people having the fear to speak out, but at the same time wanting to speak out, but not knowing how safe they are as they're speaking out. In that regard, do we get to see a weakening in Uganda's ability to actually fight misinformation?
First of all, we need to understand what misinformation is. According to the current status quo of the country, even misinformation is subjective. Usually it depends on who is misinforming. Mm-hmm. Usually when the people that are close to the government are misinforming, it is taken more like it's okay. But when the opposition, when the civil society organizations that are quite critics of the government speak, that's when misinformation is an issue. So yes, misinformation is condemned, but as we are tackling it, it shouldn't be a one-side thing. And that's okay. If we're using the law to curb misinformation, it's okay. But we should do it in a way that it affects both sides, not a one-side issue.
Okay. There's the element of cybercrime that we must also bring into perspective here on end. Specifically, sections 11 and 23 do criminalize unauthorized access to data, to voice, video recordings of any person and sharing or transmitting any information of a child. In Article 26, 28 and 29 do cover all those. Does this decision unlock an increase in cybercrime and harassment?
Realistically speaking, the law that existed even before 2011, the can of worms has always been stayed. It has been locked, and this particular ruling will not open any kind of worms in regards to cyber crimes or in regards to anything that will affect the lives of Ugandans. The way this particular for me, in my opinion, I think this ruling is quite fundamental because it will not go ahead and infringe or see an influx to cybercrimes or see an influx to misinformation. Rather, in my opinion, Ugandans have been quite respectful in the way they use the internet and with the way they even engage with the internet. And for me to argue and therefore say that there will be a can of worms that will open in regards to cybercrimes and any related issues in that regard, I would be wrong to argue that way, because the law, the way it was perfect. So my call would rather be the law the way it was, let us enforce it, let us ensure that we follow it to the dot, because it was perfect the way it is. The amendment that was introduced was one that was meant to criminalize speech. That was it. So let us just respect the law the way it was, push it, implement it, and enforce it.
I want to find out from you if you also believe that the security concerns were valid and perhaps underestimated.
Interestingly, if there is a book written by Helen Epstein termed Another Fine Mess, America, Uganda, and the War on Terror. The overriding theme in the book is on the issue of geopolitical usefulness, surveillance, and security. And Uganda has been quite vocal on the issue of geopolitical usefulness, particularly underpinning it on security. Security not only to our brothers around East Africa, but also security at home. And one thing that stands out when we talk about security is stability. And the only way you can go ahead and ensure stability is to go ahead and enforce certain ways that you can think, that you can control what people say, what people type, what people post, or what people share with each other. So for us to go ahead and criminalize what people say in regards to promoting of security, then in my opinion, that would become draconian, and that is wrong for issues of governance. But in regards to what we want for a country of ours today, is for us to freely express our thoughts, is for us to freely post what we think is right, for us to freely criticize, ridicule, and call out all the people that we think are not doing certain things right according to what we want as a country and as a people. So in regards to security, for Ugandans have been very, 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 very good citizens in regards to how they use the internet. And of course, our president and the country has invested quite heavily on security. It's the most funded in our national budget. So when you use all the resources in trying to curtail people from freely speaking and ridiculing and criticizing, I think it really doesn't make sense, because a person like Margaret and myself, who even possibly do not know how to fire or trigger a gun, the only thing we know is to hold our phone and criticize and ridicule a particular individual who has done certain things wrong. Is it wrong for me to go and to pick my phone and say, you particularly the ABC, you have done this and this that is wrong, and I have proof and I show you that you have done this and it's wrong, and you go ahead and arrest me for ridiculing you and criticizing you? Is that a problem? I believe not. So we need to have that right. And if we have that right, the security will still be in place. We just need a democratic state. We do not need to experience digital repression. Okay.
Margaret, at the end of the day, the intent is to strike as much balance as possible between protecting people online, but also policing speech. How can that be addressed?
Before I dive into that, I had something small to say about security. You see, over time, I have come to learn that when this government speaks of security, it goes beyond the stability of the country, but also security of them staying in power. That in case anything looks like it can shake their stay in power, that is regarded insecurity, which sometimes ends up affecting we the people, especially we in opposition. But when I come back to your question, you want to see how we...
In striking the balance between protecting people online, but also policing speech.
Okay. So, like...
Because we have to be realistic. There's some people who are abusing their freedom of speech. They're going out of line.
Yeah.
Okay. So, like my brother said, most Ugandans are trying very much to be well-disciplined citizens and online. And like I said earlier, It's okay, we should condemn.
Have you met Ugandans on TikTok, Margaret?
Yeah, and I'm saying we should condemn, and if anyone really breaks the law, because at the end of the day, if someone has to be charged, they are not going to fail to find a law that they are going to relate to the kind of crime someone is committing. So when, I want to urge all Ugandans to, be respectful when you're interacting with people, when you're saying something, be respectful. But if you are objectively criticizing, that's okay. If you are objectively speaking, that's okay. But be respectful. Make sure you respect one another. You never know who the person you're talking about is, you never know the consequences. But as long as you're just, asking for accountability, you're just objectively criticizing, I think that's okay. But we need to be disciplined generally so that we do not spark any issues.
Okay, so your submissions come from a good place, but let's look at the culture of our community, Uganda. By and large, there's a whole cultural aspect to it in terms of respect and not questioning elders, no matter what they've done. The Luganda Lugero says, "Omukulu takola ki tasobya," translated as the elder does no wrong. Yeah. So to the politicians that were behind this amendment, those are some of the cultural sentiments that do exist predominantly in our society, that we shouldn't speak back or against or to our elders. So in trying to strike the balance realistically, how likely are we to see that being addressed, just down here in Parliament, if this debate should repeat itself or not?
As a people, we are very calm. We are very calm people, and I think it is it's out of context when we go ahead and say that we shouldn't question our elders, we shouldn't question people in power, we shouldn't hold them to account. In my opinion, I think we have every right as a people. The fact that we are in an age 21st century, we are young people, our generation oftentimes speaks honestly, without fear, without remorse. But I understand the essence of regulation, which is very okay. So there are some people who go out of line. The law, the way it was, had an entire part that provided for cyber offenses, and it captures it entirely. All your worries and all your queries were captured in the law the way it was. My issue is the amendment that was introduces an aspect that goes ahead and criminalizes my right to criticize, to ridicule, to dissent with an individual. If you're not allowed to criticize, you're not allowed to ridicule, you're not allowed to dissent. So that means if person A says this is it, every Ugandan must go by it. That is the problem. But in regards to the question that you've asked, and maybe what we can do as a generation and what we can see differently, my call first of all comes down to Ugandans. Yeah, to when this bill or when at some point if the bill comes back on the floor of Parliament, Ugandans ought to be awake. This is to remind you that the fight is not yet done. The fight is just the beginning. That on the floor of Parliament we need to be cautious on the order of business that happens on Parliament. We need to also, first of all, hold our members of Parliament accountable. The role of Parliament is to go ahead and make law. So when our MPs are making law, as citizens, as members of their constituents, we need to remind them to pass laws that do not affect our inherent right to freely speak, ridicule, criticize, or dissent. That is very fundamental. But also to the member of parliaments themselves. I think it's very important that before they pass laws, they shouldn't pass laws on individual interests that are looking at themselves. It's quite unfortunate that this bill was introduced by a member, not even the ruling government, but in the opposition. Quite unfortunate. And his argument is the law was meant to enforce the already existing law, not cognizant of the fact that this law is going ahead to infringe on the rights of Ugandans who want to freely criticize, ridicule, and dissent with certain individuals. So on that note, I think it's very fundamental that we hold these members of parliament to account, but also to self-reflect that the law that I'm passing, is it a law that will directly make our nation a better state, or is it a law that is taking us back to the ages?
That being said, Margaret, should this come back to Parliament, what must Parliament do differently this time, and what must we see to ensure that public participation and trust are embedded in all this?
Okay, first of all, because they said by the time this law was passed, even Parliament did not meet quorum. So maybe next time, because these are the basics.
You know the Speaker is very good at mobilizing people. That won't be a problem next time. Mm-hmm.
Oh, okay. So yes, first of all, they should be procedure right, meet quorum. And then when they meet, they should make sure the public is part of this. You know, most times when you're passing the law, and unfortunately, some of these people in Parliament, starting from the Speaker and so many other people, have some knowledge of the law. So we should not be the one teaching them how the law should work, because most of them know the law, and it is important that as leaders, even when certain leaders in Parliament don't know the law, they should acquaint themselves with the law, because that is what we send them for. And much as we want public participation, the people passing such laws might not be really comfortable with the public participating. So it comes back to we, the Ugandans. Please, please, please do whatever you can. Make sure you are part of this. Make sure your voices are heard. Even when you do not know where to go, at least consult. At least let us seek legal guidance. There are many civil society organizations willing to help us. There are many very good lawyers in the country that are willing to help us, and see that we are part of this. At the end of the day, it is going to affect we, the people, okay, not the people that are passing it. So let us try as much as possible to participate in case it comes back. We have seen so many other laws that we have challenged in court. We won them, but then they came back to the floor of Parliament, and we left it.
It's a rock and a hard place, and we wait to see the response of Parliament to not only the recommendations that have been shared on the table here, but also what is the future of digital protection as far as the evolution is concerned. That being said, one minute for closing remarks. I'll start with you, Douglas.
Thank you very much once again for having me. When I started my discussion, I made mention that I'm just not here to moot the law. I'm here to discuss deeper issues. Okay. Deeper issues in regards to what this particular ruling has helped expose. And the ruling has exposed how the Ugandan state at the moment goes ahead and imagines authority, how the Ugandan state imagines language, dissent, and public order. And it's significant that the Constitutional Court went ahead and announced certain provisions of the Computer Misuse Amendment Act as unconstitutional on grounds that they do not meet quorum.
All right.
And therefore, my call out to Ugandans firstly is the fight is not yet done. It's just the beginning. When possibly this bill gets back on the floor of Parliament, they need to be involved. But also to the DPP. The DPP ought to the individuals that are being charged under this particular law that has been rendered unconstitutional to present these particular individuals on the floor of court and release them.
Okay. Yeah. All right. Margaret?
Thank you so much. First of all, I want to call upon all Ugandans, because now you have some freedom. What you can do, if you're out there and you know you have a person, of a person who has been charged under this law, please reach out to them. I am very sure most Ugandans have limited information about such things. Reach out to them. It is their time to get justice. But also, not so many Ugandans know what is happening in the country. So it just takes you a post, a speech, telling your neighbor about what is happening, and maybe in one way or the other we can spread this information, and before we know it, we have helped so many other Ugandans. And once your help as Ugandans is needed, like you said, the fight is not yet done. Okay. Please join us, don't keep silent, so that we can fight this together.
All right, thank you both for joining us here Morning at NTV to have your insights into the story of the Computer Misuse Act. That is more than just a legal journey. It is a reflection of Uganda's ongoing struggle to balance control and also the freedom in an increasingly digital world. As lawmakers look ahead, the challenge now stands on how they will regulate without restricting and how they will protect without overreaching. Thank you so much for joining us on this discussion.